Still nothing.
No, oh, yeah, it says watch live video.
Okay, we had a little bit of technical difficulty there. I apologize about that. Hopefully everything is going live now and everybody's able to start signing on. I apologize, we're 5 minutes now behind, but actually for troubleshooting in our tech world these days, that's not too bad. So I appreciate everybody joining. For those of you who don't know, my name is Tony DiUlio. I'm a partner at Wheeler, DiUlio, and Barnaby. I actually just did this spiel about 4 minutes ago, but it was to nobody because we didn't have the video actually started. For those of you just joining the call, I work in a law firm that practices almost entirely on property damage litigation, meaning that we file suit against insurance companies, neighboring properties, whatever might happen to damage a person's property, we get involved and try to help those people out. I've got more cases than I could count open against insurance companies. I think last time I checked, I had like 104 against Allstate alone. So we're very busy at what we do, and we're pretty good at what we do. The purpose of these lunch and learns that we're doing is to really focus on some in-depth policy reviews so that you guys can learn more about what's happening in the insurance world, know how to fight it, know what language to use against the insurance company themselves, really just all in all help you while you guys are in the field. My goal, what I tell people all the time, is I don't want you to have to come to me. In an ideal world, you get the insurance paid, I don't have to be involved, everyone walks away happy, great. And I can say that truthfully because I know that insurance companies are going to ultimately deny claims that they shouldn't deny. I know that they are going to underpay claims that they should be paying significantly more for. I know they're going to rely on policy language that simply doesn't make any sense because they like to do whatever they can to not pay for an insurance claim. I tell my clients constantly, insurance companies are a business. Just like anyone else, they're in a business of making money. They are not on your side. They're not good neighbors. They are really have one goal, and that's to earn money. And the only way they can earn money is by not paying insurance claims. So once the insureds understand that, once people go into it with that kind of mindset, they realize that this is not a friendly conversation of, oh, let's help everybody out. It's, I need to make sure that I have the best people on my side to fight for me that I possibly can, because they are going to be doing everything they can to fight against me. As people are starting to sign on now, I'm glad to see there's more viewers. People are signing in. I'm going to give them a few more minutes since we were a few minutes behind to make sure that everybody gets in and is okay, and we'll get started on this. Just to let everyone know, for today's topic, we're going to be focusing on the anti-concurrent causation language and the ensuing loss provision that is contained in nearly every insurance policy I've ever seen. This language, as we're going to go through today, is incredibly confusing. There's really no good way to rationalize both of these areas of language appearing in one policy in one section, but luckily we've got some case law that will help. I'll be able to describe and hopefully let you guys understand exactly how these things interplay with each other. Last topic that we had done really focused almost entirely on the homeowners side of things. Today's topic will focus largely on homeowners and commercial policies. So you're going to get a broad spectrum of application to these. When you guys signed up for this webinar, you also provided me some great questions that we're going to go through. But one of the best things that happened last time we did this and we discussed appraisals, we really got an opportunity to have live Q&A. So as you guys are going through, behind the scenes right now is my partner Mario Barnaby. He knows as much as I do, if not more, when it comes to the law on some of this. So throw your questions in there. Let us know what you need to know. I'm happy to answer them. We're going to be addressing all the questions that were put in. There were a few questions I want to let you guys know that were completely on different topics than this ensuing loss and concurrent causation. If I've got time, I will address them. If not, though, I'm actually going to use those to build future classes. So the next course that we're going to do most likely is going to be on the adjusting in the COVID world, where a lot of people do things remotely and how those remote inspections can be handled and what can be beneficial and ways to really take advantage of these remote inspections. The other thing that came up is questions about proofs of loss. Again, if I've got time, I will quickly address it, but the reality is proofs of loss can create such a quandary, such a problem in our industry when they are requested, when they're not requested. types of policy, flood versus homeowners, so on and so forth, that I think we're going to do an entire course on that too. Proofs of loss can be used to your advantage. They are really not for the insurance company. They like to think that they are, but they are much, much more powerful for you as an adjuster and a property owner on these claims than they are for any of the insurance companies out there. So looks like people are joining in. I do want to get started on some of these so we're not wasting too much time. So just so everyone can see it, nice bold words here. I am Tony DiUlio. If you don't have my contact information, take it down. One of the things that I tell everybody, use me as a resource. When you're in the field, if you've got a question about a policy, a letter that the insurance company is sending, you don't know how to respond or what it even means sometimes, let me know. I review those all the time. I will draft letters for you to the insurance company. It doesn't cost you a penny. I am happy to help with those. I truly do want to be a resource for you so that you don't have to be going to these insurance companies when they've got the backing of attorneys to you go in empty-handed. You've got me. Use me whenever you need. I'm happy to do it. All right, so jumping in. These policies, when they have anti-concurrent causation language and ensuing loss language, simply don't make sense. For anyone who doesn't know, anti-concurrent causation language, in essence, says if your cause of loss is combined with any other cause of loss that's not covered, the loss itself is not covered. Now that sounds pretty simple, and that could make sense if it weren't for ensuing loss language. Ensuing loss language within the policy clearly indicates that if you've got an excluded cause of loss, and then as a result, a covered cause of loss happens, that covered cause of loss is covered. How can you possibly work those two pieces of language together? The short answer is you can't. There is no way to properly look at this. So I want to get through some examples just to make sure everyone's on the same page here. We have, under the State Farm policy, their anti-concurrent causation language. Hopefully you guys can read this. If you need copies of policies, I've got pretty much all of them, so let me know. But in essence, it's saying we do not insure for any loss to property described in coverage A, which consists of or is directly and immediately caused by one or more of the perils listed in items A through N below, regardless of whether the loss occurs suddenly or gradually, involves isolated or widespread damage, arises from natural or external forces, or occurs as a result of any combination of these. So what they're saying, in essence, is if any of these listed exclusions is caused by your loss, you're not covered. Doesn't matter, anything else, regardless of fast or slow, it's not covered. But then what State Farm adds in afterwards is the ensuing loss language. And under the ensuing loss language, it says, however, we do insure for any resulting loss from items A through M, unless the resulting loss is itself a loss not insured by this section. Now, there's no way you can have both of these actually existing at the same time. It doesn't work. So we all generally know how this does work in the field. The broken plumbing pipe is the best example, is the easiest example. You've got a drain line in your house, the stack breaks, just from wear and tear, stack's excluded. The water damage that escapes from that stack is covered. And that's how it's always played in the field. That's how it always works out. But that doesn't actually fit with the language. Let's take a look at Allstate's language. Allstate, we do not cover for any loss consisting of or caused by one or more of the following excluded events. So Allstate gets even broader. They're saying now it just needs to consist of it. It doesn't actually matter if it's before, during, or after. It just needs to consist of it. So if your loss consists of wear or tear or mechanical breakdown, then you're not covered. But again, Allstate has the same similar language that State Farm has. If any of these, A through F, causes the sudden and accidental escape of water or steam from a plumbing, heating, or air conditioning system, you've got coverage for it. Allstate makes it a little more confusing. Rather than the State Farm policy that says any not covered loss or any otherwise not covered loss is covered. In essence, if it's a covered cause that happens, you've got coverage for it. Allstate only limits it to plumbing. So in that situation with Allstate, how do you get covered when you've got an old beat up roof and you've got water that comes into the property as a result? There's no wind damage to the roof, it's just beat up. You can't find an opening, you can't find wind damage. How do you get that coverage? Allstate adds this extra paragraph in. And this paragraph is missed all the time. I've had attorneys actually come and ask me, how and why is this covered? And I have to show them this language. The language under Allstate's is when loss is not excluded under paragraph A or B of losses we do not cover, and there are 2 or more causes of loss to the covered property, we do not cover the loss if the predominant cause of loss is excluded under paragraph D immediately below. So what does that mean? It means as long as the actual damage that is you're claiming, the water damage in the roof example that I gave you, as long as the predominant cause of that loss is not excluded, you've got coverage. This is actually really hard for Allstate to fight because it's actually extremely difficult to prove what is the predominant cause of loss. Now, the water claim is really easy because, well, we've got water that actually caused the damage itself. Sure, maybe something happened earlier that allowed the water to get in, but the thing that physically damaged my items, my structure, my floor, my clothes, whatever it may be, the predominant cause of that damage is water. So it's not that my clothes are worn and torn. It's not that my somehow mechanical breakdown of the water heater caused the water damage, the actual water on my clothes or my floor or whatever it is. That's why that ensuing loss is ultimately covered. This goes even further beyond the homeowner HO3 policies. Anyone that works in the commercial industries understands that there's the BP policies and the CP policies. Those policies, just like any other, has ensuing loss language. It also has anti-concurrent causation. This is one that's pulled from the standard basic form, or I'm sorry, the special form. The special form for exclusions. So their exclusions: we will not pay for loss or damage caused by or resulting from any of the following. So wear and tear, rust, all your normal players in the game. But they then add in the same ensuing loss language. But if an excluded cause of loss that is listed in 2D1 through 7 results in a specified cause of loss, you've got coverage for it. Again, having these terms interplay with each other is nearly impossible to actually make sense of. You can't have it. You can't have something that says that any damage that is caused by or resulting from wear and tear is excluded, except if it's not. Because that's what this is saying. And that just doesn't work because this is an absolute. There's no restriction to this sentence until you get to further on down the reading. With all of these, and every claim you have, you need to make sure you read the policy so that you know how to use this language. I obviously can't use this time to go through every single policy that's out there, but you need to have an opportunity to review them and understand how to read these things so that you can fight for your clients as much as possible. Understanding the actual language of the insurance policy is the most important thing and the biggest benefit that you add to your clients because they don't understand insurance policies. They are not experts. It is nearly impossible to understand these things unless you are really in this industry. So make sure that you have an opportunity to review their policy. And we're going to get to a question about what happens if you can't get that policy down the road. So now we've seen some examples of what I mean when I talk about anti-concurrent causation and the ensuing loss language. Now, the courts have looked at this pretty closely. Again, I can't go through every state in the country, so I'm going to focus in PA, New Jersey. For those who don't know, my firm focuses their practice on the East Coast. I personally am licensed in Pennsylvania, New Jersey, Virginia. I'm getting Maryland and New York currently, but I've got counsel all over the place. I've got attorneys in North Carolina, Florida, New York. If you need somebody, Maryland. If you need somebody, I can still handle those claims and assist you with those. So please feel free to let me know. Ask me those questions too. Luckily, these policies are pretty consistent across all 50 states. I've reviewed claims and entered ProHawk all over the country. So if you've got questions in other states, feel free to let me know about those. But let's take a look at what the courts have said in some local areas. Pennsylvania. In Pennsylvania, the court looked directly at this ensuing loss language in two pretty important cases. The first one was actually one of my files. And overall, I actually wasn't a big fan of this decision in the Ridgewood Group case. It was a case that was entirely about whether or not water that came off of a roof entered a concrete window well for a basement and then entered the property, whether or not that could be excluded as ground or surface water. That was the only fight that was going up to the appellate court, and what the appellate court did is ruled in my favor and said that is not ground or surface water. It never touched the ground. This is not what the policy means. So hooray. But the court went one step further and despite there being no arguments made by either party on this issue, came back and said that, well, based off of the language, it's ambiguous when it comes to this ensuing loss language, and that the ensuing loss language is ambiguous. However, the Ridgewood case came back and said, we're going to interpret it based off of foreseeability. And that simply was not the law in Pennsylvania. Candidly, it's still not the law in Pennsylvania because of this Griggs case. But they tried to base it off of some California fire cases that came down. It was really an absurd ruling. But they got one thing right. It's ambiguous. And it is unquestionably ambiguous because of the problem that we've been talking about this whole time. That in essence, you can't have a policy that says, we're not covering it regardless of when it happens and what happens with it. Oh, but by the way, we will cover it if it's the result and that result is covered. It just doesn't make sense. That is on its face ambiguous. So they did get that right. And then we've got the Griggs case. And Griggs came back and said, Ridgewood, you were right about it being ambiguous. You were dead wrong about how you interpret ambiguous policies. Pennsylvania law is crystal clear, as in most states. Any ambiguity in an insurance policy must be read in favor of the insured. So you cannot come through and read that language in a way that favors the insurance company. You must read it in favor of the insured. So that language comes out, and ultimately that ensuing loss language is what holds the day. That if you're going to put that language in there, you can't back out later and say, I'm sorry, you're not covered for this. New Jersey did a similar thing. New Jersey's case law isn't as flushed out as Pennsylvania on this, but they ultimately come back and say that that ensuing loss language is the enforceable language under the policy. So if you've ever got a conflict, if you've ever got conflict in the policy saying there's coverage in one spot and that coverage is taken away in another spot, you ultimately go with the coverage. So make sure you are reading these policies. This is how you get around anti-concurrent causation, because the ensuing loss provision will prevail. The policies are different though. Remember, you just looked at State Farm versus Allstate. Allstate has a provision that says predominant cause of loss. That word predominant doesn't exist in the State Farm policy. So make sure that you're able to review these policies so that you're in a position to fight these further and get the right outcome for your insureds. Now, that's my brief overview on this, but we got some really great questions from in the initial signups for these classes. If you guys have more questions, please add them in now, right to the chat. We're having Mario monitor them. He's adding the questions as they come in. So if you've got more, please let me know. If you don't, that's okay. We'll be done sooner rather than later, and I'm okay with that. But that's one of the big benefits of this, is to know that you have me as a resource, even live now, to ask whatever questions you guys may have. All right? So let's take a look at this. Hopefully you guys can read these. If you can't, I'm going to be reading them to you anyway. If there is mold after a water claim, can the insurance company deny the entire claim? This might be the best example of the conflict between anti-concurrent causation and ensuing loss. And here, it actually gets reversed. The cause of the damage that you guys will always be claiming, always, unless there's mold coverage, is water. The word mold should never be an issue at all. You don't need mold remediation. You don't need any kind of antibacterials. You want to keep everything mold out of the claim and make it crystal clear to the insurance company that the only thing you are claiming is water. And the reason that is so important is because as long as your claim is water, there's no exclusion for it. That there's no reason under any language within the policy that says that that water damage isn't excluded. Let's use the Allstate policy as an example. You have a water loss that occurs to a property. The water damage is covered. However, mold starts to form, and Allstate excludes the mold damage. Under the language in the Allstate policy, they say is the predominant cause of the loss that you are claiming excluded. Here, you are making no claim for the mold. Doesn't matter if it happened concurrently at the same time, afterwards, before. Doesn't matter. All that matters is that you've got the coverage for the water damage. And if that water damage is covered, you're good. So whenever you present these, you want to make sure that those words like mold, rot, decay, deterioration, you obviously want to avoid those words at all cost. And the other hard part about this for the insurance company is that they have to be able to date some of these things. What do I mean by that? Well, mold, first and foremost, as most of you should know, starts in 24 to 48 hours. There's a fantastic FEMA bulletin out there on this. It's got great pictures. great description, and it is bold as day. Mold begins within 24 to 48 hours. So just because there is mold doesn't make this a long-term problem. The next is the rot and the decay. Similar issue. You've got a water loss that occurs to a bathroom. They open up the ceiling. They see that there's a rotted joist. Well, when was that floor joist rotted? Maybe it was 50 years ago when they had a prior water leak and it's been repaired and it was fine and it got wet again. But simply because that rot exists doesn't mean that that rot is excluded, or the entire loss is excluded, I should say. That water claim is still covered unless the insurance company can prove to you that there is a correlation between this leak and the rot that you're seeing. They can never exclude it as a result of that. That's really going to be an important thing because the insurance company can't do it. There is no way to date rot. So sure, a new construction home, you're going to have a hard time with it. But if you've got a 100-year-old home from row home in Philadelphia, if you've got some of these old properties, there is no way that they're going to be able to tell if that floor joist, that subfloor, was rotted as a result of this leak, or if it's a rot that they just simply built over in the past because it was secure enough. It was sturdy enough to build on, so they just built on top of it. Use those types of arguments to your advantage to make sure that you're maximizing these claims. Always remember, it is the insurance company's burden to prove the exclusion. They have to prove to you why they're not paying a claim. If they can't do that, they can't exclude the loss. Here was another interesting one, and I took some liberties with what this means, and if the person who asked the question has clarifications, let me know. I'll be happy to address it. Flood causes hot water heater pipes to break loose, causing 75,000 gallons of water to fill up basement. Travelers denied. We filed as accidental discharge of water. Claim was denied after they denied the initial drain overflow / subsurface water claim. Thoughts? So this is interesting, and this is how I took this to mean. That there was a flood, an actual flood, a storm flood, that caused water to enter this property. For one reason or another, that flood causes the hot water heater to break, and now there is an escape of additional water, 75,000 gallons, into the property. My assumption under this question, without more detail, is that those two water losses mixed. That in the basement of this property, there is now flood water that's entered the basement, and there is water from the broken water heater. Depending on the policy language, you might have a shot, but it's going to be hard. First, if those damages truly are fully overlapped, the water mixes into that basement and you can't tell what's what, you're not going to have coverage for that. There's no way to distinguish, for your perspective, to be able to prove the damages that were the result of the water heater, because that's what you would have to do. Your burden is to say, here's what was damaged by the water heater, and that's what I'm claiming, not what's damaged as a result of the flood. Now, if you've got an ability to separate that damage, let's say the water heater is on left side of basement, floodwaters came in the right side of the basement, and you can make any kind of distinction at all as a result. Well, depending on the policy language, Allstate, for example, the predominant cause of your loss to that left side of the basement is the hot water heater and that water that came from there. You will have coverage for that in that situation. That is about the only way you're going to get it, though. You've got to be able to distinguish those damages and only show the damage that was the result of that hot water heater. If you're able to do that, then you've got a good shot. Again, so much of this comes down to the actual policy language itself. I can't tell you the numbers of times that I will get a question from an adjuster out in the field who says, hey, the insurance company is claiming this, take a look at the policy, what do you think? I like doing that. I actually enjoy breaking down these policies, so use me as that resource too. You guys can contact me anytime. Again, that contact information is down here. It'll be sticking around that corner this whole time, so anytime you want to reach out, feel free to let me know. All right, this gets to the question. Obviously, you need to read the policy language to determine how/what exclusions apply. What can you do if the insurance carrier refuses to or delays the delivery of the certified policy to you as the public adjuster? I can't tell you how often this happens because it happens all of the time. Insurance companies will constantly be trying to go out and not provide these policies because they realize exactly this. They know that if you get the policy, that you've got the upper hand. So they want to push this out. But you do have options. There's only so many times you can request it from them, but I would recommend you only need to request it once. And if they don't provide it, then you get a higher power involved. And I don't mean me, I mean the insurance department. The insurance departments don't like to get their hands into the nitty-gritty of an insurance claim. They don't care about causation. I've never seen an insurance department complaint work when the complaint is, hey, the insurance company says my loss was caused by X. I'm saying it's caused by Y. Can you step in and do something? They won't get involved in that. It's simply a judgment call, and they're not willing to do that. What the insurance departments hate is when insurance companies aren't responsive. So you can use them immediately. People think of the insurance department as this kind of last-ditch effort, like I've got to try everything under the sun to get these documents. That's not the case. The insurance department actually wants to hear from you if there is even the inkling of a problem with these carriers. Let's take a look at what PA law says. PA says that if the carrier fails to acknowledge pertinent communications, an appropriate reply shall be made within 10 working days on other pertinent communications from a claimant which reasonably suggests that a response is expected. There's really no way to take a request for the insurance policy other than a communication that suggests a response is requested. So when you send that initial letter, if you don't have it on business day 11, 2 weeks later, you should notify the insurance department. CC the insurance company on it, and that is your fastest way to force their hand. Now, most likely, they will send you the insurance policy themselves. Most of the time, they're going to do that, and then you can tell the insurance department, don't worry about it, they sent it over. But you've got to have that stick to say, look, if you're not going to play ball, then you've got to make sure that the insurance department knows, because they're going to come after you for it. And they're going to have to explain, if they don't turn over this policy, what possible rational basis they would have to do it. I'm going to tell you right now, they don't have one. It's the contract between the parties, so they need to provide that to you. So use this early. There is nothing that says you cannot communicate with them because they simply haven't communicated in 2 months, 3 months, 4 months. Those are the timelines people think, but it's not true. Use them whenever you can. Anyone who doesn't know, there seems to be a freeze. I don't know. There we go. Just so you know the names of the departments for the local areas. I know there's some people on here from other areas, but it's the Pennsylvania Insurance Department, it's the New Jersey Department of Banking and Insurance, and it's the Maryland Insurance Administration. They have different names, but they all do the same exact thing. They all monitor the conduct of these insurance companies. They monitor the policies, although not very well. They're the ones that you want to get involved. Again, I can't stress this enough. There's no reason you need to wait. All right. Moving on to another one. This was another interesting question. There is no exclusion for earth or soil pressure. Therefore, when a collapse happens and it can be shown that the wall fell because of hidden decay, meaning rusted rebar reinforcements lost strength, can the insurance company claim hydrostatic pressure and prevail? This is actually a really interesting one because this happens all the time. And I have almost this exact case for a property owner where we had to sue both a waterproofing company who clearly failed to do the job properly and caused damage, and the insurance company for the ensuing collapse. Collapse coverage is an additional coverage under most insurance policies. And what that means is that when you have a collapse that occurs, you've got to go to an entirely separate section of the policy to explore whether or not that collapse is covered. Those additional coverages, most of the time, don't have applicable exclusions or don't apply the normal exclusions that occur within the policy. What do I mean by that? The collapse additional coverage is specifically enumerated as to when a collapse is covered. If it's not one of those causes of loss, you're not covered for the collapse. But it doesn't work the reverse way. If the excluding cause of loss, let's say earth movement, causes the collapse, that earth movement exclusion doesn't apply to the collapse coverage because there's no tying language in most insurance policies. There's nothing to associate additional coverage to those exclusions. This gets a little complicated and confusing, so if I'm not doing the best job of explaining it, I apologize. But what really this comes down to is those additional coverages are pretty much separate from the rest of the policy. There's nothing that ties those to the remainder of the policy. Think of it this way. We use this a lot in our COVID claims. The civil authority coverage is additional coverage under the policy. There is a virus exclusion that says it applies to the exclusion sections within the policy, and insurance companies are trying to say that if there's a virus exclusion, it must apply to civil authority. The problem is a number of these virus exclusions don't say that. They only say they apply to coverage A. Additional coverages are not coverage A. Those are two separate items. And that's the distinction you need to realize. Because if you've got coverage A that has an exclusion, sorry, you're not covered. If you've got an additional coverage and the exclusions don't apply because it's not coverage A, you've got coverage. Long way around it. I've tried it a few different ways, but hopefully that makes sense. How that applies here. If the collapse was caused by that hidden decay, the fact that there is water pressure, groundwater pressure, earth pressure, whatever you want to call it, on the outside isn't going to matter, as long as you can prove that the cause of that loss is the hidden decay. Because that collapse language doesn't have any of the anti-concurrent causation language that you're generally worried about. It doesn't exist under that additional coverage. Remember, this is a contract. They have to be able to tie the language of the words to the facts that actually happened. If they can't do it, then you've got your coverage. Hopefully that makes sense. If you need a little more explanation on it, I'll be happy to give it. Let us know in the chat any more specifics on that issue. All right, insurers say they're not going to pay for the flat roof assembly when it's nailed down underneath the steep roof assembly. Basically, the shingles have punctures through the modified Bittman and flashing as one of the overlaps to the other. The insurer will say we are not paying for the flat roof because it wasn't damaged. Is there any way to get this covered under the idea of concurrent causation? Now this one's interesting. It took me a second to kind of figure this out, so I'm going to put my clicker in my pocket for this. You've got, and you guys probably knew this. I mean, you read this and you probably got it quickly. It took me a second. You get your pitched roof with shingles, and it abuts the flat roof. That flat roof goes underneath, and that first course of shingle gets nailed down through the flashing and the flat roof, whatever rubber roofing, whatever the roof is made out of. Your shingle roof gets damaged, it's got to come off. Now you've got flat roofing with holes in it, and you've got to nail back down to it. Is there anything you can do, as I understand the question, to get the flat roof portion replaced? It's a tough fight. I was talking about this with my partner before we started today because I was really trying to figure out what the best argument here is going to be. Here's your problem. The whole purpose of the flashing in that flat roof is to cover those holes. So it doesn't matter if there are holes there because the idea is that the water is being shed by the shingle roof portion. So you've got a hard argument to make that it needs, for any protective purposes, that needs to come off. Your better argument, if you've got one at all, in my opinion, is to say that there's not a good nailable surface to attach that first course of shingle to. And what I mean by that is you've got a number of holes now throughout this flat roof portion in the flashing there. And when you go back to nail that new roofing down, if even one or two of your nails catches that prior hole, it's not going to be as secure as if it would otherwise. It's way more susceptible to wind. That's not pre-loss condition. You need a tight seal there. And that's going to be your best argument to say, look, it's almost like a continuous repair, right? You need to make sure that you've got a continuous repair until you've got a tight seal and a fully nailable surface. If you present it that way, very similar to if you've got the damaged decking under the roof, you've got to replace the decking. Even if it wasn't damaged as a result of this loss, that decking has to come off because you need a nailable surface. It's the exact same argument here, so you can use that. I've got to be honest though, it's going to be a tough fight. If you've got a roofer that's going to be willing to write a report for you, that's going to help a lot. All right, taking a look. How can I avoid making a claim for mold if I have to present mold testing and mold remediation based on expenses to support the claim? Good question. So if you, first and foremost, obviously if you've got mold coverage, you don't need to worry about this. But why do you ever need to present mold testing and mold remediation if there's no mold coverage? I would never present mold testing and mold remediation if you don't have enumerated coverages for mold and fungus. If it's purely a water claim, you've got to tell the homeowner, I'm sorry, I can't put this in because this is a red flag for the insurance company. And make it up in the rest of your estimate. Hopefully you guys have gotten pretty good at writing these that you can try and make up that cost somewhere. But ultimately, you can't present the mold damage and the mold testing as part of the water claim. Because as part of that water claim, that's going to be where your exclusions start to trigger. If this ever comes up in the field and they say, well, look, you did mold testing, you did mold remediation, You can say, sure, I'm not claiming it though, right? That would be my answer. I would tell them pretty straightforward. Yeah, the homeowner had to do that. They had to protect their property. They've got to protect themselves. They had to do that remediation work, but I'm not asking for you to pay for it. It's not covered under the policy. I'm not gonna put a claim in for something that isn't covered. What are you talking about, Allstate? So make sure that you are only presenting this information if it's actually going to be covered. Otherwise, it doesn't matter. The insurance company doesn't need to know about it. Insurance company shouldn't know about it if it's not going to be something that's being claimed, right? It doesn't. Think about it this way: you're making a claim for damages to your kitchen as the result of the leak sinking, or the leak sinking, the sink leaking. You don't need to tell them anything about that second floor that's got smoke damage from your kid lighting too many candles, right? Has no bearing. One doesn't have to do with the other. This obviously feels a little more attached because it's water and mold, but the reality is there is no correlation between the two of those things. So feel free to just not present these damages if there's not mold coverage. If I've misread your question or there's more follow-up on it, let me know. I'm happy to discuss it some more. If the carrier declines to provide the policy, is that considered bad faith? If that alone is not enough to litigate, is it a step towards that? Good question. Bad faith isn't usually a definitive line of this is enough. Most of the time, bad faith is ongoing conduct. It's multiple things that come up over time. Simply not providing the policy, I think it's bad faith. I think it is egregious for them to do it. The truth of the matter is it's probably not going to be enough for the court to do it, but it is absolutely a step in the right direction. The fact that the insurance company is trying to hide that policy from you is really egregious to me. And what they're going to say is, well, we sent you a policy, back when you signed up, you should have had it. I'm going to say, well, sure, that's true, but every year after that, since you've renewed it, you've never sent me a new complete policy. I've never had the full thing. I've never had all of it together. How am I supposed to have a good review if I bought a policy from 1985 and it's 2016 now? You've sent me 1,000 endorsements, but never the full policy. So you've got to send it to me. I would absolutely use that. But really, you're never going to need to get to me on this issue alone, because you now know to contact that insurance department and you're going to get a copy of it. At the very minimum, when the insurance company responds to the department and they have to provide you a copy of that response, they're going to attach the policy to it. So you're going to ultimately get it, and that's going to be way faster than going through me. I'm happy to write a letter, make a phone call if you want to see if that speeds it up. But a lot of times they give me the same runaround that they're going to give you. So yes, it's a step towards bad faith. That in and of itself probably won't be enough. All right, guys, I think those are all the questions. If you have any more in the next 30 seconds or so, feel free to throw them in there. I really appreciate you all joining me. These courses are not meant to dive into every aspect of every policy with ensuing loss and concurrent causation. They're meant to give a specific overview of them, but to keep it somewhat broad because we simply can't go through every policy. This is how you're going to be arguing the cases, though. You're going to be arguing that there is no way to apply both concurrent causation and ensuing loss. It's your best way around it. If you can't do that, then you just have to focus on, I'm not making any claim whatsoever for whatever the excluded portion is, has nothing to do with my loss, and as a result, it's not being claimed, it's not excludable under the policy. Allstate's a great example of that with the predominant cause. So use that type of language against them. If you've got specific questions, if you're ever looking at a file and say, hey, look, they've claimed concurrent causation, let me know. It gets way more complex than this. There's, I don't know if he's on the call, there's an adjuster I was just talking to about a week or two ago about State Farm's weather conditions exclusion, and actually a number of carriers that have that exclusion. Still to this day doesn't make sense to me. I've run it by every attorney in my office. I've run it against defense attorneys. Nobody actually can make heads or tails of it. These policies are filled with things that just don't make sense. So if you've got those questions, I can't stress enough, guys, please use me as a resource. We've got my information down here.
There's one other question. What if a carrier won't send an expert report for some other issue like a roof report?
Great question. So that comes up probably as much, if not more, than with the insurance policy. For anyone that just, in case you couldn't hear my partner Mario, they're saying, what if they don't send the expert report that they're relying on to deny the claim? They constantly will claim that there is no requirement that they do it. And candidly, they're right. There is absolutely no requirement that they send you that actual report, as long as they cite what the reason is in their denial letter. They can't just say, we had an expert go out who inspected your roof, and as a result, we're not covering your roof. That's not good enough. If they wrote in their denial letter, we had an expert go out to the roof and he discovered X, Y, and Z things, and as a result, the exclusions apply, that's good enough for the denial letter, but it still doesn't help you because it doesn't get you the report. I would still contact the insurance department. And I would say in the complaint to the insurance department, hey, I'm trying to make an evaluation of the conduct of the insurance carrier and their denial, and they're refusing to provide me the information that they're relying on. How can I possibly do my job as a public adjuster, or how could I understand it as a homeowner if I don't know what they know? If I don't have the information that they have, how is that ever going to happen? Because of that, that insurance department will very likely step in and get that report over to you. If that still doesn't work, give me a call. I've got a few contacts and I've got a few tricks up my sleeve that we can do it somewhat painlessly, but it does take a little bit more time to get these documents. It involves the filing, a filing with the court and then what's known as pre-complaint discovery, but I can do it if I need to. Just let me know. All right? Guys, thank you so much. I really appreciate it. As always, you can contact me whenever you need. We'll have this recording available if you need to come back for any reason. Thank you so much. And I really, really appreciate you guys and everything you're doing for the industry. All right? Thanks, everyone.